We're short one then. I gave Keith the.
I got 21, 28.
You have that one? The other actually 31.
Don't worry about it. Oh, there it is.
What's that? Yeah. That's the game. Well, you're doing something.
Yeah, that's all, you know, otherwise.
We are ready when you all are. Tim, are you good?
Bernard? Can you see the screen on there, Bernard? It's not glaring or anything?
It's not glaring, it's
Okay.
dim,
It's dim, okay.
yeah.
Just so you know, we have a captured high fidelity.
Yeah, I was gonna ask about that, because I was looking at the YouTube video from Monday, and it kind of, when we had the documents on the screen, it was kind of hard to read, and so.
That was a problem fit for years. That's why we researched this solution.
Okay.
Yeah, we showed it to Bernard, and I think he might adopt it at some point perhaps, but it's really good. It captures it as a video stream rather than capturing off the wall.
Okay, okay. Will you also share those links?
Absolutely.
With us,
Yep,
like you did
absolutely.
last week? That would be really
Yeah, I'll try to just get you guys access to the folder so you can just go in there and whenever something's new, and I can text you, let you know or whatever. But I'll try to make it easy.
Sure, great. Well, we really liked the status update that y'all did. I think it kind of lets us know whether we're on the same page or not, and just sort of where things are. So we wanted to do a similar status report and update from where we see it, and I think we're all on the same page. And I think what this also shows is that we're really making some forward progress. So,
Your graphics are much better than ours.
well, the theme is, let's all hold hands and shake hands and make a deal.
I love it.
We have big clouds, which is kind of common.
I saw the clouds.
Kind of dreamy, It's too bad, but this is good.
Well, if it's dreamy, is it in reality? I think a contract is in reality, so.
Yeah, that's a good point. Do not use cloud computing.
This just kind of shows what we've done so far. This will be our 4th session. I think we're making a lot of progress. These are just the next 2 sessions, but clearly we have a lot more dates coming up in June. So T8 articles to date. You see we've got stock clapping hands for us. T8 articles to date, ground rules, which we've already done. We've signed Article 5, signed Article 6, and Article 20.
I don't show us signing 20.
I have it signed. I'll make sure that it's emailed to you. But
Will you sign 20?
I believe.
Okay, we'll just have to check on
Yes.
that. I just have it different on my blog.
Okay.
And that's why I think these are good updates to
Yeah, exactly.
throw us up.
Exactly. Proposals that we've received from y'all to date: 1, 3, 4, 5, 6, 7, 8, 10, 11, 13, 16, 20, 21, 22. So you'll see this includes stuff that we've already TA'd as well. This is just kind
I
of
got it.
a progress
Together.
report of what we've received so far, and we really do appreciate all the work that y'all have clearly done over the past few months just to get us what you've already done. So what we have responded to thus far, and this doesn't include what we're going to provide y'all today. We're going to talk about at least 8 articles today, so this doesn't include that. But what we've responded to so far is 1, 3, 5, 6, 7, 8, 11, 13, 20, 21, and 22.
Okay, so it's okay to talk you through this?
Yeah, go ahead, ask
Okay.
questions. Yes.
So I'm showing recognition we sent you 4 different versions. I think you came up with a 5th version, which we said, okay, and I thought it was ready for TA.
And that's something I
But
also
I think
wanted
it's on
to.
your side of the table, not our side of the table.
Yes, and I think we're close. I think it's now a matter of grammar, and we just have not gotten back to it.
Well, you're right. We
Yeah.
have a singular and plural in the same sentence,
Yeah.
which we tried to resolve
Right.
initially.
Yeah.
All of our versions do, by the way.
So we just haven't been able to circle back to it, but I think it's basically ready to teach.
Yeah, I'm just letting you know, I think it's on your side of the table, so.
Yes, okay. And this just means that we've responded to it. You have probably already, it doesn't mean that you haven't responded back.
Okay,
So-
yeah, I understand. Yeah, I'm
Yeah.
doing it a little differently, like what side of the table it's on.
Oh, okay.
And I
Okay.
understand what you're doing.
I just don't want it to make it seem like, whether it's on our side of the table or your side of the table, I don't want to make it seem like they've been unanswered as of
Gotcha.
yet. So we,
Makes sense. Can
so,
I see the rest of that list? I'm
Yeah.
sorry. And we think we either TA or going to TA contract with this. And we
Correct.
think I think we're ready to TA or close to TA PEs.
correct.
Okay.
Correct. And you'll see 5 and 6, it's been TA'd already. It's still on that list as what we've at least responded to in some way, shape, or form. So,
Okay, thank you.
So the city has reviewed language and is ready to TA these, so these aren't in that list. So 21 is in that list. 25 are ready to go. 29 notice is also ready to sign. Article 32, the line of duty deaths that y'all have proposed language, we have no changes to that. We're gonna go ahead and accept it
Okay,
as you have proposed.
that's great.
So I've got these ready in final form. I can email you those after this morning session.
Perfect.
Counter proposals that we will talk about today will be the Civil Service Commission, Article 26, Article 28, Article 30, and Article 31.
Let me notate those, please.
Sure.
All right, thank you.
And pending articles with no proposals from either side are just these. So I again, kind of referring to what I mentioned earlier, it really looks like we're making some forward progress.
Yes.
So,
If all articles were created equal, we're making incredible progress.
let's
Well,
be
actually,
optimistic.
you know what, this one doesn't have, they'll probably give it today, but this doesn't have hiring. Hiring, there's not been.
And we are prepared to present that
Yeah.
after this presentation.
That's fine. And so Bob, here's, Sylvia pulled this up, but here's a signed Article 20 that you signed with Lowell on May 18th. So I think this is already TA.
You sure it's my signature?
Pretty sure.
I also emailed it, so it's in your emails right now.
I appreciate that. I don't recall that. I thought it was still pending and, and we had kind of a agreement, but apparently I was not as correct as I thought it was.
That's all right. Take a look
It
at
happens.
it. See if we forged it.
See if we forged it incorrectly.
There's a better way to copy your
Yeah,
signature, please. Les.
I have a dossier. It's not even in the dossier. It's all of it.
Articles actively being discussed. So the preamble, recognition of association, which I think we're close on.
Okay.
So just, we just need to come back to it. Association dues, ABL leave, shared communication, which we proposed to y'all last time, we're still talking about that. 13, personal deployment, Article 16, promotions. I know we got it in the afternoon session on Monday. We just really have not had an opportunity to go through it yet as we were going over the other articles, so it's still actively being discussed in Article 22. And I know y'all had mentioned in your presentation on Monday, articles y'all consider in conflict. And we wanted to just kind of reassert that, or reaffirm that we're still definitely talking about that. They're not necessarily off the table in any way, shape, or form. The health benefits, we're still talking about. The personal deployment and the one-way trades, we're still considering. So we're just kind of, I think we're trying to kind of get the low-hanging fruit right now. Let's see what we can agree to, and then we'll come back to the little more complicated ones.
Yeah,
that we want
and
to.
conflict is probably just type of word that our labor association would use, but we're really meaning the same thing. We're just kind of putting it aside, hoping to work on them later, and there's no reason to let those hold up the rest of the process. That's kind of what we're looking at.
And just to, y'all had made the commitment last time, and we just wanted to make the same commitment to y'all. We are definitely willing and wanting to come to a deal within this time period, the 60-day time period, and we're here, we're committed, and we're ready to work with y'all.
And we're glad to hear that, because and we are too. Because I think sometimes it's very, very common for each side to think they're the side that's being righteous and the side that's not being, I think it's very common in any negotiations or in sort of group dynamics. That's why we express it as much as we do, and I think you express as much as you do. We really do want to get a deal at the table.
And we understand we're gonna have conversations and disagreements at times, and we're willing to do all that here at the table so we can I think we all have the same interests. How we get there, we might disagree on, but we're all fairly on the same page.
I think that's a great thing to reaffirm.
That is it for that. So we can go over our proposals for this morning, unless you want to do a status update.
Yeah, I would, but I gotta make that one change to grievance. just
Sure.
So it reflects correctly. I can't have time to change the cloud graphic, unfortunately.
Yeah, it's just talk about.
Maybe you could, you probably.
Maybe on graphics.
Take me a little more.
No, a lot of times.
Just so that we have it.
Yeah.
College. Hiring is 7. There it is. I'm putting it in the wrong place because I wrote it wrong. Just a second.
What was good, it's 20? It's 20, right?
Yes.
Like to get it right. Forefront. These are not, no, it's not up here. Oh, there we go. These are not dream clouds, these are clouds of vision. You see that, which is almost as good as the graphic you had. Think about it. And so, all of that work, I put it in the wrong place. I should have had grievance down here too, so I think that's the tentative agreements we have. And I put grievance in the wrong place, soon to be tentative agreements, I believe, is recognition. You may have some other stuff, I thought we were close on that one. Shared communications and PDEs, which I show is similar to what you guys had on your side.
Yeah, the only thing we added have on ours that you don't have on yours is 25, 29, and 32.
Oh, that's right. Which we wouldn't have had on our presentation, 25. Yes, I will add that for next time. Thank you. Articles on your side, and this will be a little different from what you said earlier today, but I went down the list. I think we're pretty close to being the same. Right now, we don't have any articles on our side that we feel that you've responded to us, and we need to respond back. So if we're wrong on that, or you have a different perception, let us know. We'd like to present hiring. We can do that after you present your articles if you like, or whatever sequence you want to do it in. We're prepared to do that during this session, as you prefer. We're still kind of looking at the wellness thing. And, we haven't done a lot of work on it. We had a meeting with the IFF where they're starting to kind of look at this proposed language. I don't think it would be very overbearing. I still don't think you guys would like it, but I don't think it'd be very overbearing, so we can discuss it. This is what we plan on having proposed by June 3rd. So we're going to be working on this hiatus between today and next Friday. And potentially proposals means our goal is to get all of these proposed, but sometimes goals don't work out. We want to kind of signal to y'all what we're thinking and working on. So we plan on bringing you wages and leave and hours working overtime. And then that would allow me afterwards the things that have been unestablished would have been discipline, which we really don't think we have a lot of changes to make. We just don't know with all the work we need to do when hours of work and wages, we'll have time to deal with it. Same with civilian, there's no motivation for these being here, other than we just kind of looked at what we thought was a very important articles, what we could do in the next week, and that's what we're working on. Substance testing, what do we want to call it, article. I think we're all thinking like maybe we'll hold off on that until there's more progress in EMS, we'll see how that goes. And then we hope to have the new wellness article after the June 3rd. Just to kind of give you all an idea of our tempo, what we're trying to work on, so you can plan accordingly. And this just leaves kind of the same list you had, minus some of the things you're doing today, things that are left non-discussed today. And then what we're calling the areas of conflict, which we could call them several different things, but I think we've identified items that it's going to require extra work for both sides to get an agreement at the table. Maybe that's a better way of saying it.
Well, hey, we haven't added to it, right? So,
I'm sorry?
we haven't added to it, it's the same
Yeah.
four as last week, so.
Yeah, that's good, right? But a lot's going to happen today, so we'll see. That's all we have, and we could let you present, or we could present our hiring article, whatever you prefer.
Why don't you go ahead?
Yeah.
Let's go ahead.
Yeah, sure.
Already plugged in.
See if I can move that little slider thing you guys always remind me to do without being asked. Wouldn't that be amazing? That's probably the biggest I can make it. Other people could probably make it bigger. It's big.
If I can see it, it's good enough.
Yeah. We believe that this article is fairly mature. We would expect management to have some suggested changes, particularly the one I think we would like to see management propose. I believe we will, on how to make the cycles work quicker with less latency, lag time between cycles. But there's been no more time spent on any article the last 10 years than this one. It's been the scrutiny of the consent decree, the hiring process been through the scrutiny of the consent decree. It's been exercised many times. We think it's worked very well. And once we have our reports back, we think we can demonstrate this worked very well as far as adverse impact and validity, which validity is important. Validity is basically talks about how well the test predicted good performance. So mainly, I think almost entirely, unless I'm mistaken, you will see us stripping out elements of the consent decree. And occasionally grammar change. I don't mean to go so fast. If I do, just let me know.
Sure.
But I don't think there'll be a lot of question. I think mainly I'll be saying we're stripping out the consent decree here, we're stripping it out there. Let's just make sure. Yeah, I imagine you guys have the same sort of elements that you want to remove because they don't matter that much anymore. Again, all consent decree stuff. Taken out. This was pretty much consent decree stuff. Well, not pretty much, it was consent decree stuff. I think we added video conference here because that's become a thing. It used to be so crazy you would never do it, now it happens every day. That's all consent decree stuff from our perspective. left in all the merger stuff, although I think it's a lot less likely with the new changes to annexation laws, but, I think the last time we talked about taking it out, the city felt like there was some benefit to them, so we left it in, we're not changing any of that now. We do talk about resolutions using, dispute resolution procedures here, which is the difference. Internship programs, I don't know if you guys remember the history of this, but we offered this in exchange for nothing, less contracts. We think it's an important thing. I think it could be viewed as something that's really good, but then when you get down to the actual elements of trying to make it work, it becomes very difficult. And that's why I think you need to negotiate very carefully. For instance, by the fact that we're a part of a program, we can be sued if you guys don't do the program correctly, which we have been sued in the past on hiring process for the exact same sort of thing. And so we are definitely supportive of an internship program. The times we made some suggestions on how you can possibly do it last time. We can bring those suggestions forward again. But I think if you're looking at an internship program, some of the things you look at is, can you meet goals you're not meeting with the regular hiring process? And maybe you can and maybe you can't. But it's still subject to same Title VII regulations. So you can't make race-based decisions and make selections for an internship program. So that makes it harder to achieve certain goals like diversity. So we are open to it. We think it could perhaps have great value. I think it really could, and I think there might be some ways to accomplish all the goals, and if we get creative with it. But I do think it needs to be something that needs discussed either at the table or somewhere else later, as we imply here. And it has to be done very thoughtfully. So. Federal process, again, all the exit studies showed that this was an utter failure. You can see two of the people from our committee that doing the process. But actually, there was a lot of great people who came through, but a lot of people thought it was a little too short. We did not lengthen it. We did not change it at all. I'm just making that comment. The after action studies at the time said the academy should have been several weeks longer. But we're not changing it. We're not trying to dictate anything there at all. Train, I think we pretty much left exactly the same. And again, I think this has worked well. It's produced good cadets. All this has been exercised many times over the years, and I don't think it's been problematic. And even though sometimes we don't, like in the hiring process, oversight committee, that's been a very successful, I should have said this earlier when I said, that's been a very successful committee. Now I might have a totally different opinion, but I don't think that's a committee we'd ever done without this article. We brought men and labor together to talk about how we hire cadets. But I think it's been really good discussions at the table. I think we've made really sound decisions for the most part. I think sometimes neither party gets exactly what they want, but when you look at the outcome, I think it's been a good outcome. And I think we've taken very few votes. We've taken a few votes. We haven't had the necessity to take votes. Most of the time when you have information in the form of your decisions, you can reach like conclusions. It seems like that's what's happened, is the stakeholders have been able to bring in information from different sides that informs the board. I think it's been very valuable. So, you got to occasionally talk about something that works, right? I always thought extenuating life service is an artifact that needs to be removed, because it's from a time when we had hard standards written in the contract, like if you don't get a 70, you get knocked out of the academy. If you fail a retest, you're not going to the academy. We took those things out. And so I always thought this was kind of an artifact of old times that could be taken out, but I brought the same arguments before, and management was insistent it stays in, and we are fine with leaving it in. But I also think it does not add much value, considering we provided more global flexibility in other areas. So whatever you all want to do is fine. I would just like to lower this article by a quarter page. I don't think it hurts or harms, honestly. We struck this, I think we need to talk about this. So there's a big exposure for the association here. A big exposure. And it's not just a theoretical one, it's one we've practically been a part of. We've been sued by the EEOC. It was thrown out when they got all the facts, but it cost a significant amount of money, and the city at the time had a clause to indemnify us, and they refused. I think you remember that happened in your office, though. And so now, we're talking about giving allowances to the hiring process again, and you limited us last time $150,000. But yet, when you propose dues, you want unlimited indemnification from us. It seems inequitable. So I think that, I'm not striking it because for any other reason, then I think that needs to be discussed. This whole indemnification thing probably needs to be discussed more, if that makes sense.
Yeah, I do think it'd be curious, Bob, for you to ask Craig and his team, and we'll ask our law department. Yeah, I know it's a sore topic for y'all, the indemnification from 2013.
It's not a sore topic.
15. And I understand, I understand the frustration you guys expressed at the time, I do. I think it'd be curious to find out what your lawyers think, and I'm gonna find out what our lawyers think. If this article, because you're right, this has been the one that, has caused impasse numerous times before, but shockingly, I don't think we've ever gone to impasse over money. And we've gone to impasse over hiring, maybe some other things, but I don't know if there was a time where you just sat there and said, this is not enough money, we can't take this, we're at impasse. I think it's always been operational issues that have taken us there. But I think it'll be curious to find out what Craig thinks and what our lawyers think. If this article goes to arbitration, and the arbitrators make a decision that is not what you wanted, that is not what we wanted, how should we be liable then? I think it'd be curious if someone wants to sue, we can say this wasn't our language, and you could say the same thing. I'm just curious what the lawyers think about that.
Well, let's not take this one to arbitration.
I'm just curious, but that applies globally, for any of this stuff.
I can tell you right now, we have no desire to take this article to arbitration. Zero, none, zip. So it would be phenomenal if something changed in our environment, we take this to arbitration. You could avoid that by not taking this to arbitration.
Well, but the general, I'm more being just a legal geek here at this point. I think the legal question applies to the entire contract. If someone were to sue and that language actually was imposed by the arbitrators, I'm just curious what our liability actually is, because we could say this wasn't us that came up with this language. Anyways,
I don't know that answer, but I can tell you arbitration is not odd. We do arbitration all the time. We just haven't done interest arbitration and contract negotiations.
Right.
And so many times an arbitrator will obligate both sides to certain actions. And I think it's a good question to ask if the boogeyman pops up and does something really terrible, are we liable? But I think if you look back through different interest arbitrations and arbitration, we've had that does not happen.
Yeah.
Or it happens so rare and so limited that it's not the sort of scary thing that we're contemplating perhaps.
Yeah.
But I do think they're good important questions. It's just that you can study interest arbitration, not find those sort of outcomes.
Yeah. Okay.
And I think that would be a great, if you guys brought this to interest arbitration, I think we'd both be arguing for the same thing, to make sure that there's outcome that is legally defensible.
Yeah.
Under federal law. And I know that doesn't quite answer your question, but I hope it helps that you understand what our philosophy is on it.
Yeah, I got you.
And yeah, at the time it was an issue, but we're beyond that.
I know, it was a while ago, I'm just saying, I recognize your.
This is more like clear-eyed, objective stuff. We just, you're talking about a federal lawsuit, $150,000 is nothing. It probably needs to be $450,000, and then you probably will capture the cost 90% of the time. So this article, if we don't mess with it, And I think you guys, it's likely you would want to make some changes. I'm not saying you wouldn't, but if we don't change substantively the process we have, they have stood the scrutiny of the DOJ. They've been exercised over many years. They've had good results. You never have perfect results when you have a hiring process, because you do all the things you do at the beginning of it to give you the highest % chance of getting the outcome you have, and then random things occur. But I think you'll find when you look at other processes across the nation, and there's always a balancing between validity and adverse impact, you will find very few, if any, process. The DOJ could not, by the way. The DOJ counseled us when we got together and said, listen, your process looks pretty good. In our process, right? I'm not saying my process. But we think we make it better. And we had some of the best industrial psychologists in the nation going through it, and they couldn't make it better. And so I think in terms of validity, this thing is gold standard. It's already been through DOJ scrutiny. In terms of the outcomes we've gotten, it's been very good. And so we feel strongly that the substantive parts of this article should go unchanged. But we understand you could have different opinions. So. And that's it. I'll send it to you once we get back to our caucus room. By the way, why did we get the best caucus room? It just seems like
I've
it's so
not
much
been in
better
that
than
room.
y'all's.
I thought it kind of smelled like burnt food.
Yeah. Well, there's, some of these young kids will not turn on coffee.
That's a faulty copy. Did it shut on by itself?
I'm gonna absolutely learn that lesson.
Firefighters,
No.
fire hazards.
The look she gave me, she was like, you know, you guys need to be more careful. It's a fire hazard. Who was in that room? I was like, okay, I'll abstain from answering, but we will be more careful. You know,
This sort of badger humiliation is terrible. Oh, I'm gonna hit the button that gives you the
Yes.
access. Just make sure you got the right thing in your screen. And more importantly, not the wrong thing in your
We're
screen.
not the wrong thing. Okay, so we'll just go in chronological order from ones that we said we're gonna discuss. So Article 8. So your language is still up there just for kind of historical purposes. And we really had a lot of conversation internally because we completely understand what you're trying to say in your proposal, right? Oh, can you, yes. And we agreed that there should be no ex parte communications with any member of the Civil Service Commission concerning any commission proceedings. But the way that it appeared to originally be proposed was that it could restrict, like, one of the assistant city attorneys even talking to their supervisor, so I think the lines can get a little bit fuzzy.
Yeah, we didn't intend that.
Yes, and then referencing the Texas disciplinary rules of professional conduct, we're already covered and bound by that anyway, and if there is a complaint about us as attorneys or the city attorneys, there's already a competent adjudicative body that will handle that. And also what we didn't want is kind of pulling in the disciplinary rules. Is that something that could possibly get put in an arbitration or some type of grievance process, so that's, we didn't want to expand that. And then we actually did look at this rule, we looked at the rule regarding confidential information, and then it references other rules, other rules of disciplinary conduct. So it just seemed to kind of expand it a little too far.
So you unraveled our plot then.
Well, we didn't, I'm gonna give y'all the benefit of the doubt that is not what y'all intended.
No,
But we didn't want to overcomplicate it. And I think we had originally proposed a counter proposal with some language change, but then after further discussion, we would really just like to leave it as is. It does cover ex parte communications with the commission. I don't think we've had any issues of this. At least I'm not aware of any, unless you know.
Yeah, we have our comments in the footnotes.
Yeah, we do have a comment in the footnote, which I will send to you.
Yeah, and I think we think you have some valid commentary about being too broad, and we didn't intend to do it. I do think it needs some language that talks about the philosophy of what we're trying to accomplish. And it's simply that a city attorney should not be providing or promoting city positions to the commission. And that the attorneys assigned to the commission, which is I think is necessary, but they're only there to counsel, you know, to help the commission with whatever their question is, whatever the legal issue is. But they're not there to persuade them on the city position. And the reason why this would never probably go to any sort of hearing board is it's all honor system, right? To a large extent. If I have ex parte communication with a commissioner, you're not gonna know. But I'm not gonna do it because we're signed an agreement saying we're not gonna do it. And so it's all really honor system. I think we've gotta lay out what the principles are for that honor system.
So you're proposing possibly kind of like some language like the intent is, or you know, something like that.
Or maybe a little more practical than that, but, you know, the city attorney cannot, that's assigned to the commission to advise them on germane issues in front of the commission, should not, you know, support, should not try to persuade them on city positions. Something, I mean, it needs to be better than that, that's what I'm trying to get to.
Okay. Did you want to take this and kind of rework what you've?
I can do that if you'd like, sure.
Okay. I mean, we're happy to continue to have this conversation. What we're not trying to do is sort of the way it's worded right now, not reveal any confidential information. And that doesn't necessarily mean they're advocating by providing, you know, attorneys talking with each other.
It's just so silent on it. It seems like you would allow the city attorney to advocate for a city position. We just want to make sure that's clear that's not appropriate. And I don't think we could ever grieve on it. I don't think we could ever allow anything. I just want people to understand the honor system we work under. You know, and it's important that they don't have. It's important that if we, the whole thing about ex parte communication, I'm not an attorney, of course, but is that we create a space where the commission can make decisions without being unduly influenced by outside influence. But the way we have it written, an attorney can consult. It doesn't, it's silent on whether they can advocate a certain position. We just want to make it clear they shouldn't be.
Right.
If that makes sense.
Right.
That's it.
Okay.
But I'll be happy to reword that if that's good.
Yeah, I mean, just kind of thinking that through, the word advocate may be something that you want to look at, but I also want you to conceptually think that if I'm an attorney and I'm advising the commission as a city attorney, and I believe that the association position is illegal to adopt, that would be advocating them
That
to
would
not
be an
adopt it.
objective legal fact. that you're bringing
Exactly, so
information.
just
Yes.
kind of be careful how you reword it to keep in mind that they do have to, under their own legal duties, give advice to the commission, even if not solicited, if they feel that it's something that could put the city in legal jeopardy.
That's
So-
helpful. I'll try to make sure that's included.
Yeah.
Thank you. And we're not trying to stop that.
Yeah, it doesn't sound like it, it just
No.
sounds like you're trying to separate the,
It's probably why it was never done more than it was before. 'Cause
Yeah.
It's not as easy when you try to write it down
Yeah.
as it seems.
I think our general belief is that that's what ex parte communication means, so
Right.
it's already stated, but we're happy to.
Kind of like the use
I
of
can see that point
yeah.
of view too, yeah, I understand that. So maybe if we can just make it a little more clear in that relationship with the attorney of the commission, but not go too far, and we'll try to do that.
Because, yeah, the kind of the use of the term ex parte, that's sort of the intent behind it is that there is no ex parte communication unless you have both advocates actually there talking to the
Yeah.
commission, so.
But then that means I could just talk to the commission too and just say, well, it's not ex parte communication. I'm just trying to explain that the associate's position is legal for these reasons, you know, so.
Well, exactly,
you know,
but,
Yeah.
but on the counter side, you don't want, Matt can't talk to Craig. You know,
Right.
so.
We don't want it to go that
there's a-
far.
Yeah, there's a
Yeah.
No, and
fine
I
line.
don't wanna, we don't wanna impede that either. I think we can,
Okay,
this might not be the one that,
conflict.
that that puts us past the 60 coverage.
Huh? Throw it up in your clouds.
Yeah, yeah.
Okay, 26. So, this is y'all's, proposal here where you've struck out this second half. And, you know, we've been putting footnotes here. So we also had a lot of discussion about this. You know, this language I've seen in many other contracts. It's just like standard, old language. I've seen these two sentences in some variation, shape, or form. very frequently. And I recall in your presentation of this proposal that you all acknowledged that this was a big change. And so I kind of want to just have a little further discussion. I don't think the intent is, and when I have seen these particular type of language brought up in prior contracts, it's usually when we're at the arbitration stage and you know, the sort of the concept that you can't get in arbitration what you didn't get in negotiation. And I don't think that's what you're all are attempting to do, but you all did acknowledge it was a big change. So I kind of want to just get a little more clarification on that.
I mean, so there are elements of this thing we struck that I could understand, the acknowledgement that we both had the ability to discuss everything at the table, right? I think that might be something that's, you know, we could add back or whatever. My concern is that we feel this section also contemplates that even if we don't have the knowledge of things at the table, that they can't really be brought forward between contracts if conditions change, like a working condition or benefit changes.
And
we
with that,
think that is central to the tenets of collective bargaining is the continual duty to bargain.
would that not be covered, like partially covered anyway, in like maintenance of standards and things like that?
Our concern was this would negate some of the language from maintenance of standards and management rights. So if we can come to agreement that it does not impede the clear language of maintenance standards and management rights, then this wouldn't be as important for us to strike. We take another look at it again with fresh eyes.
So you're trying to preserve impact bargaining moving forward throughout the rest of the contract?
Yes.
Okay. And we don't
think
have,
we think has always been there in a collective bargaining environment. We just want to make sure that it is there going forward. And if we are incorrect in our interpretation of this, then we can talk about the table and correct our interpretations. And if there's elements in here that you wish to keep, I can see there are elements you would want to keep, and some elements I'd like to keep. I'd like to acknowledge that we would freely exchange articles and talk about everything, you know, that's great. And that's not what we're trying to stop.
Right.
We're just trying to make sure this does not detract from management rights and maintenance of standards in any way.
what we have not ready, at least this morning, is management rights. So with your commentary, we'll kind of we'll do another look at our management rights article to see if maybe we can kind of work both these out.
Okay.
And
Yeah, and so I might be totally wrong. And if you guys say, no, this doesn't really impede any of the clear language in management rights or instead it has this other purpose, well then, we're probably in agreement. I just wanted to have that conversation.
Okay. Savings clause. This is I think y'all had proposed no changes.
That's right.
This is mainly cleanup, and our footnote says that here, cleanup language. If any provision of this agreement or the application of such provision, I don't think we're substantively changing anything, declared invalid by reason of existing or subsequently enacted legislation by any court of competent jurisdiction. It previously said legislative or judicial authority. I think that's what we've included is what the current language basically means. We're just kind of cleaning it up. Such invalidation shall not invalidate the remaining portions hereof. All other provisions in the agreement shall remain in full force and effect of this agreement. Some grammar change there in that sentence. And the parties shall meet as soon as possible to agree on substitute provision. If the parties are unable to agree to a substitute provision, I think it just clears up that sentence there. Then the parties will meet within 30 days until collective bargaining negotiations are next held. It says resumed, but what if we're not in the middle of negotiations? So just next held. And then we added some language here that we're not going to count like ratification time within that 30-day period. So if we've come to an agreement within the 30 days, adequate time for ratification shall be granted either from your side.
Well, that's probably a good idea.
So we consider this real cleanup, not anything substantive. If you see something that you think you have a problem with, definitely let us know after you've taken a look at it.
Yeah, it seems okay, but of course we'll have to let our attorney.
I understand, yeah. proposals, continuation during negotiations, and interest arbitration. So, we have our footnote down here. So basically, we would like to mainly keep our legal rights and, that we have just within the bargaining process, which includes the ability to have this evergreen period. Obviously, in some contracts, it's a little bit different. Y'all have 30-day increments up to a total of 6 months. If y'all are wanting to, now that we do have interest bargaining as kind of the backdrop of these negotiation sessions, if you wanted to talk about a longer period, I don't think we're not unopposed to that by any means. But this is something that we're gonna need to get authority and approval from the city council with anyway. So just simply writing it in here, really would like to keep our legal rights in regards to that. So, and then also I think it was Matt who included the parties engaged shall begin negotiations by such and such date. I think that's already governed by 174. So, just within the certain time period for the fiscal year. So that's mainly the reason we struck that out there. But otherwise, we left his language specified in section 1A above as the end date. We just need to add some years in there, depending on the term of the contract. But that's mainly our position here as for the first change.
So I don't think you guys would agree, and I'm asking this if you do, we're really happy. I don't think you guys would agree that we just write binding arbitration into the contract, because that solves all the legal issues. We could install basically the city charter amendment into the contract, and then there's no legal issues. There's absolutely none. They would bring up, even though we think the ones that could bring up now are not frivolous, but very minor if we lose in court. So is that something you all would be interested in, is adding into the contract all the provisions from the charter amendment into the contract?
As of right now, I would say probably not, based on the fact that there is some uncertainty within the law. And I might be speaking too soon.
Yeah. Well, it takes away the uncertainty if you put it in the contract. There's case law that shows that. So if you wanted to eliminate legal uncertainty, you could put it in the contract, and that would eliminate, you can research that, but
right.
It would eliminate the legal uncertainty, okay? But that's been settled in, I think, Corpus Christi. I'm assuming you don't want to do that, and that's the way we're operating. That's why I'm asking the question. If I'm assuming wrong, let me know.
I think you're assuming right.
Right.
Pardon me?
You're assuming right.
Yeah. So I've been told that it's not just legal issues, there might be some economic issues in the city. They balance those when they decide to go forward, and we know all that because all that was discussed surrounding the council resolution. I'm just trying to be candid about all that.
Yeah.
And so I want to be candid about this. We have no intent of writing anything in this contract in a clandestine or explicit way that puts the city charter inside the contract. We are not trying to do that. And if you think we are, we're not. If we write something you think that we're trying to, we're not. If we can do it unintended, we'll change it. So I just want to go on record right now that we're not. We made promises with the agreement in writing and with the resolution. We made promises beyond that we intend to keep. And we want to preserve the city's right because that's the promise we made. I think they have to get permission from the council to take action, but we are absolutely behind that. We're not trying to support that in any way. I just think it's important to say, because if you see things about interest arbitration, I want you to know what our motivation is. It's not to try to backdoor putting the amendment into the contract, but we think that the savings clause would solve this. Okay, so if we do need to acknowledge in the contract certain things that involve interest arbitration, if we feel strongly about that, then we're going to want to advocate for that, and we'll need to get back to our attorney and just need to watch these tapes and just look at your discussion. Because I think that if there's an argument that the law could change, the savings clause should save that. It should take care of that. And if we need to enhance that more to do that, then let's do it. Because we don't want to take away any promises we made surrounding the agreement and stipulations or the resolution. And we won't. But there are certain necessities we do need to add in the contract because of interest arbitration. That's the only balance we're trying to reach here, just so you all know. Does that make sense?
Yes.
Is that make candid enough on that? I just want to make sure.
Yeah,
We're just kind of laying all the cards on the table.
Yeah, we'll have some questions about that, probably for the next time. But like on this one specifically, I know you've added interest arbitration at various parts of your proposals, different articles, but on this one specifically, I just don't know if it's even necessary because, you know, the language in the charter has specific timelines for when, you know, when we need to declare, one side can declare impasse, when you gotta submit your names, when the arbitration hearing has to start, you know, and we already have a built-in 6-month, you know, option to extend. Now, if you wanna make that permanent and say, hey, you know, right now it takes 2 to tango, it takes both sides to agree to 30-day extensions. If you just wanna make that permanent, that's one way to resolve it. We just think if you start, you know, you're being candid, I'll be candid with you. Y'all are traditionally the last ones to start, police and EMS will start, but even if you start last, and even if we get to impasse, based on the timelines in the interest arbitration section of the charter, we're gonna get the deal done well before the six months are up, you know, a decision back from them. So I just don't know if it's necessary is the way that I'm trying to say it. So, but I do understand if you're saying, well, but Devin, the language on the 6 months right now takes your approval for 30-day increments, right? So we want to change that up and just solidify it, that there's a standard 6-month evergreen, that's something we can look at.
I gotta say, I love the candor,
Yeah.
you know? And I mean that in all seriousness, because that's how we're gonna get a deal at the table. And so if you were to make interpretation of this section, and I'm speaking out of turn a little bit, so everything I say our attorney needs to look at, and our attorney needs to advise us on rights. But if you were to say that, so our interests are here is that, you know what, the city may just take this arbitrator and say the contract doesn't have anything about interest arbitration in it. You know, we think that the procedure is right here under continuation of agreement, so we're not gonna do it. You know, in fact, we're gonna grieve it, you know. If that's not your intent, and you know, it's very common for both sides to give the sides of the, you know, have something up their sleeve, right? But if you were to say, no, we absolutely, as long as the law allows and it's not challenged, to do all of the tenets of interest arbitration as per the amendment, and we don't look at this as something that's grievable, we just think this is, it doesn't need to be changed necessarily because we have this other component that we will use. Until we don't. If that was the interpretation, then we would probably be less likely to need some of these changes, if that makes sense. We just want to make sure we don't leave an exposure that where you might grieve it because it's not in there. If that makes sense.
I'll talk to our lawyers, but I think we're on the same page, actually.
Okay.
I think so.
I do too.
What we think is when you put this in there, yes, you may be trying to tackle the city not having an out, but we think when you put it in the contract, because you said you can resolve any legal issue by putting it in the contract, but that's exactly what the council wants to reserve their right to do if the Supreme Court case turns out one way, but we have it in the contract. Now you're going to say it doesn't matter what the Supreme Court said because we put it in the contract, so we have to go to binding on. And
I understand.
Then that kind of takes away the whole purpose of.
And we are
the
absolutely not
caveats.
trying to do that.
Yeah.
So, you know, I think this has been a very productive conversation. I think we can get beyond this.
Yeah.
And I think the signed agreement and stipulation, I mean, that's the plan, is going to arbitration in the event of impasse, and still preserving our rights, depending on what happens in the Texas Supreme Court. And so that's all we're trying to avoid here is we don't want to sidestep what's already been agreed to, and then y'all come in and say, well, y'all agreed to this, so.
Yeah, well, I've made our position very clear, and you guys, it's on record, and it's part of the history of this negotiation. And we have no intent of trying to write it into the contract unless you're willing to do that. We think that does solve some of the problems. But
We'll get you. I mean, I have an answer I want to give that I think would satisfy you, but I want to make sure I cover all the bases. So we'll talk to our legal team who worked with your lawyers to come up with the conclusion and all that stuff.
well, we should be able to come back with something because I think it was a very honest, productive conversation. I appreciate it.
And then we've added some language to funding obligations.
I'm sure you guys have seen this before, it's in the EMS and police contracts.
Yeah, I might have seen it, but I haven't really.
Yeah, so what it had to do with, in the last contract cycle, which you guys beat out timing wise as to when all the legislation was getting changed regarding tax caps, it tried to just protect the city from any limitations on resources and funding. So although the city intends to, comply with everything that it agrees to, it gives a way that if the city is limited by tax cap or other legislative actions such as that, to incrementally reduce what was offered to you. If you'll see, we go to the next page, actually, Becky. If you look at the example, you'll see well, actually, can you show both? Sorry. It's really de minimis. For example, if in the parenthetical, for example, if there's a scheduled base wage increase of 1% and the legislature reduces the city's revenue authority from 8% to 6% through a legislative tax cap, the effect on the base wage increase for the relevant year would be a decrease of up to 2%, resulting in a 0.98% increase for that year. So it's very de minimis. It's just the same incremental reduction that the city was given, and of course the city's budget is much larger than just yours, so it just takes it incrementally. So a 1% increase would be reduced to a 0.98% increase, and that's the example.
And so the potential issue we could have with something like that is every program being incrementally reduced the same, or is it just labor associations' wages?
It's a contractual obligation under the bargaining agreements. Whether or not city council would do it to other employees, that would be up to city council.
Programs, right? Because
Yeah.
city budget, city salaries or total payroll costs are
Right.
significant in the city, but they're not all the spending, right?
Yeah, but in order to enter into an obligation to fund a base wage increase through a long-term contractual agreement with one of the three entities who's entitled to a long-term contract, the city is looking for a commitment from you that if they give you 1%, if they give you 10%, that on a long-term basis, if the legislature makes it impossible for them to do that, that your part in agreement is, well, we'll reduce it by that small fraction. So that's what they're asking for.
Well, so how this was discussed before, and I think I don't have access to those, I have access to tapes, I just don't have the timeline. The discussion was that it would be more like the city is in default before this would happen. And now we're saying something quite different, perhaps, is that, if the city is restricted on the ledge side, they could, in some formula, reduce the wage increase. So
Yes, that's exactly
we
what
need to
this
think about
is.
this quite a bit,
Yeah.
because that's a pretty significant difference from the city's in default, we can't fund things.
Yeah, you're
Yes,
right.
That's not at all the same concept.
Yeah, so the top portion, the part in black, yes. I think when we had those discussions in 08, 09, that black part revolves around inability to pay. Doesn't necessarily means the city's bankrupt, but pretty much.
Yeah, but that was the
It's-
implication, that's
that's
pretty
right.
close to that
That's
sort of
right.
environment,
Okay.
you know.
So what happened, y'all didn't have to deal with it in 17, or maybe you did at the table, but either way, it did not make it into your contract. But by 2018, the threat of a tax cap coming from the ledge was very real. And so we put in this exact language. In honesty, we should probably lower the numbers for the example rate, because it used to be 8, and in the example, we put 6, but as we all know, it's 3.5 now.
Right.
So I'm not so sure that there's going to be another decrease in the next 4 years, potentially, so two legislative sessions, because they just did it, decrease down to 3.5. But what we got from council, I will tell you, was a mandate in 18 that both of those agreements have to have some protection for if our ability to collect taxes goes down, then our obligation to pay increases, not decrease your current wages, but to pay increases, should be reduced accordingly. What we heard, obviously, you're not gonna be shocked by this, from the other two unions was you didn't make fire signs. And we said, well, they got a deal in 17 and this wasn't as big of an issue, and it is an issue now. So this is the exact same language that the other two have. This is the exact same language that we haven't, gotten a deal with both of them, obviously, or either of them. But this is the exact same language that we're gonna keep in the agreements with them to the extent we get an agreement, so. Yeah.
I've never, I probably have seen it, but never really thought about it much.
Right.
I appreciate the explanation. and
Yeah.
History of it. I think that, we need to look at it carefully. My inclination is that if something's triggered with the ledge, we should get back together and negotiate, not just have some sort of formula reduction. But let's take a look at this and we'll get back to you.
That was 30? Yeah. All right. So I don't think we show your changes in here, actually. That's an error on my part. So I apologize for that.
Yeah, I don't remember what they were.
It was to include, going to arbitration, binding arbitration regarding the charter amendment change. So you added the charter, amendment language in there. And our position is that we don't really have, that y'all, you can get with your legal counsel, I guess, that don't really have the authority to agree to include EMS in the binding arbitration, because the charter doesn't go that far. And also, we're concerned that it would violate the current contract that we have with EMS. So that's kind of our position on
I
it.
never thought about.
Yeah, I mean, let's say you say, hey, if you merge EMS in, they cannot get our wages, they're gonna get a different set of wages, and that's our proposal. We say no. And you wanna take that to binding arbitration. We don't think you or the arbitrators have the authority to make terms and conditions of work for another group that's represented by their own membership, by their own union.
Yeah, I would,
So,
and I may have wrongly thought this, but I would think that the arbitrator wanted your testimony from EMS and bring that into the ruling. But, maybe I'm mistaken on that. So we need to think about that more, and I appreciate your thoughts on it.
And then I think 32 we agreed to, so that's it in terms of our counter proposals. I'm gonna email these to you.
Okay. That sounds
As soon
good.
as we get back to our.
Yeah, that sounds good. I thought I had another question, but I don't.
Well, if you do, certainly can ask us.
And so I'm not sure what we're going to perhaps bring back later. We'll look at what you sent us over today, and we might have some response to some of that. I'll send you our, well, you want me to, I'll send you our PowerPoint, because it kind of talks what we plan on doing on the 3rd, if that's helpful.
Okay.
And I'll also try to establish some sort of protocol. We get you those videos kind of on a recurring basis. So I'd have maybe ask if that's helpful to you all looking at the video streams of this. And what do you all have time for this afternoon?
I mean, I was gonna say the same thing. I'm not so sure that, I mean, we have a bunch of work to do on some of the stuff you've given us and some of our own things, so I'm not anticipating any other proposals from our end back to y'all today. The only thing that matters for like Bernard is if we can commit now, we don't have to, we can commit now that, hey, will this work, and then come back on next Friday. Then he can put a sign up saying, hey, we're done for the day, so anybody watching knows not to.
Yeah, I don't want to say, we could have a short caucus, we can come right back in and let
Okay.
you know. I just
That's fine.
need to say that without talking to my team.
That's fine. And, Bob, you may have sent this over, I don't know, but just for our records, last time we came, you introduced some new folks saying they're not part of your original 9. I don't know if we ever got the names of who is
I'm
on
happy to
your
provide
core
those.
teams. Yeah, perfect. Good.
Yeah, I guess.
We're trying to play a shell game, but we will lay it out if it's interesting.
And can we confirm that TAs, that they agree with on the record, so if we sign them off the record, they're already on the record?
Yes.
You identified what they were, I just wanna make sure.
Do you want me to
they
put
agree.
this back up real quick?
Just real quick.
Real quick, you guys had mentioned Monday that you guys might have a salary comp study for today. Is that gonna happen?
Probably not. Yeah, we talked to them, there's some additional things they need to rectified in there and clarified. So we have another call with them tomorrow. But as soon as we get that done with them, we'll send it over to this. And it sucks timing wise because I see y'all are probably gonna have wages meeting next Friday or the meeting after that. So, you know, I obviously would have preferred to get this to you sooner. If you can hold off, we're not gonna hold it against you if you wanna see our comp study before you make the proposal, but,
If we don't have the comp studies, we're hoping that might help inform some of our decisions. We'll probably commit to more next Friday as a conceptual wage proposal, and then we'll kind of wait for the full one until we see your comps.
okay.
Your vendor is PFM?
So what I'm gonna send you also for signing TAs is Article 21. I believe, last Monday, we agreed to our language changes there. Article 25 is no changes. Article 29 is no changes. And Article 32, the city is accepting y'all's language proposal without any changes.
Okay,
So I will send those over for signature.
that's great. You mind if we take a short caucus?
No,
Bill,
go ahead.
just determine we're not gonna be.
Yeah.
back.
Yeah.
camera keeps dropping this. Give me 1 second.
Okay, we're back on the record, just to confirm with you that we are not gonna meet again today. We're going to exchange the TAs that we discussed on the record in writing with you and reduce those to writing, and we'll confer on some further dates that we'll announce on Friday when we meet, a week from Friday when we meet.
And you'll send us your proposal, we'll send you, Irene.
We will send you
your
everything.
proposal, we're working on that.
Absolutely.
Well, I just want to say I appreciate all the candor in this discussion. I think it actually was very productive, and they're gonna move us much closer to the contract, so thank you.
Great.
Appreciate it.
That sounds good, thank you.
We'll see you Friday.
See you then.
I presume you're caucusing most of the day, then, right?
I'm sorry?
I said I presume you're still using the room and caucusing most of the day.
Yeah, we'll be there for at least a couple hours, I would think.
Okay, we can go off the record. I can show you or Bobby where the key is kept for next time.
Okay. That'd be helpful. Excuse me. Jim, that should be it for the day.
Okay.
Now I'm gonna talk to you about what the link issue was after.
Talking to Brooklyn today, that fall in this category. Those who purchase land after the complex fire, that'll steal a deal. I think they're going today, right?
It's 8,500 acres of 15 findings of 15 next was before 30 at 65,000. They appraised with 20,000. Bank it. All together, they're on 15. Claims and revenues. No, for sure.
But the opportunity is playing out.
Oh, no. There's no way there's 15 acres.